Hi all. So welcome back to the business contractual relationship course. And today the expectation is to describe and discuss on the contract of employment, dismissal, termination, and discrimination. But today we are expecting to discuss on the contract of employment up to the point of termination or the cessation of the employment. And from for next week we are going to discuss on dismissal, the ways of termination, and how can you treat different. There are different ways of terminating contracts, right, by the employer, and the discrimination on the contract of employment, right. Okay, so basically the employment discrimination, right. We'll move now here today. What is an employment basically? Now before you come into the contract of employment or law of employment, you must know what the employment is, right. You can say it's a job. Yes, of course, it's correct. But employment doesn't mean that it is a job, right? It's basically an agency. Some of the people are saying that employment is almost an agency in some cases, right? But an employment is a relationship between two parties. Basically, if you're known as, let's say that is employer and employee relationship, right? Relationship between two parties, usually based on a contract where work is paid for, where one party is an organization or employer and the other party is the employee. So these are known as the employments. So there are basically four conditions known as two parties, right? And there's an agreement between the parties to the contract of employment, and also the employer's responsibility is towards towards the employee, and employees' responsibilities and duties are towards the employer. So they are having a commitment to each other to perform their whatever the agreed things to them. Okay. Now, who is employer and who is an employee? Basically, if you look at this picture, you can say this is an employer and this is your employee, right? But when it comes to the employer should not be a manager. When it comes to, now let's say, when it comes to the corporate sector, you can see some of the names. As an example, let's say these are not paid or unpaid promotions, but of course I should say, right? If I say ANC Education, right, that is a legal personality which is already been incorporated by the Companies Act, that is a company, right? So that is a legal person. So that becomes the employer. ANC Education is a legal employer, right? So employee is a person or an entity who hires another to perform service under an expressed or implied agreement and has control or the right to control over the manner and means of performing the services. Now, in case of the employee agrees to perform some of the duties and responsibilities under the terms and conditions given by the employer. In that case, the employer is having the authority to control over this party, since they are having the control, because why? The employee has already agreed to the expressed and implied agreement terms and conditions, right? So employer is a person who has or an entity who is having the hires someone to perform the services under the express or implied agreements and has the control over the persons in means of performing the services, right? That is what you're going to own as the employer, right? The total opposite of that is the employee, the person who comes to work, right? Employee is a person who is hired for a wage or a salary, right? There are two ways, right? The first one is wage and salary. If you look at the wages are paid daily, right? We call them as wages as vetana, right? Salaries as vato. Salaries are paid for the people, those who have hired or recruited for, let's say, that is like almost permanent or contractual employees. We will discuss about them later, right? But wages are paid for the daily people, right? The daily workforce, or let's call them as the casual workforce, right? Wages. Fee, it can be a fee as well, right? Fee or a payment to perform a work for an employer In agency law, the employee is called an agent, the employer is called the principal, right? So this is basically a principal and agent relationship, we are known as in agency, right? Okay, so that is how we define the employer and employee. So we'll get to know what are the duties of an employer. What are the duties of an employer? Basically, duty to pay the reasonable wages and salaries. Now, if you look at, if an employer is not paying the duties the wages and salaries to the person who acts their duties and performs their duties and responsibilities, he is not a good employer, as well as the employee can have the legal actions against the employer, right, saying that he is not receiving a reasonable salary or a wage. And duty to provide work. Now you cannot, if you are an employer, you cannot expect or you cannot let an employee to become idle, right? You must provide the work as well. If you have recruited somebody, right, you can see most of the, in government sector, you can see some of the people are in their, waiting in their offices without work, right, because they haven't provided with their work, right? So providing work is one of the duties of the employer, right? And duty to repay the expenses. By the way, if somebody hasn't provided the work to the employee, presuming that he is not doing or she is not performing a work, they cannot make the pay cuts, right? Let's say they cannot reduce their salaries, because that is up to the employer's responsibility to give the work to that particular employee, right? You cannot cut the payments, right? Even if the person hasn't provided with the work, so then you must pay the salaries for in full, right? And then duty to repay the expenses borne by the employee for work. So whatever the cases of agency, right, whatever the expenses made by the employee in an event of let's say for a work, actually those things has to be mentioned in the contract of employment. We will look into that later, right? So that is what you call as indemnifying the employee from all its hazards and damages or whatever the recurrences. So that is called indemnity, right? So repay the expenses, like basically the petrol wastage which has happened in connection with traveling from his home to the workplace. If the employer has initially agreed with the employee, so the employer has to pay it, not in a way of salary or a wage. It has to be paid as an indemnification, as an incentive. It can be as an incentive, or it can be as a sort of a let's call it as reimbursement, right? And duty to vicarious liability. Now there are some things called as the vicarious liability, were known as employer held liable for the acts and omissions of their employees, right? So vicarious liability comes under the employer, right? Then what are the duties of employee? Now employee should obey the lawful commands of the by the employer to him or her, right? But that has to be lawful, right? Unethical, illegal commands cannot be performed, as well as they should not be performed. And also, if somebody if the work scope hasn't defined any sort of that sort of act which are known as unlawful or illegal, so performing them will create creates the agent in a sort of a sufferable situation, where no one is going to protect them, because those are like whatever the acts made illegally or unethically, or basically not unethically but unlawfully, those are indemnify the employer from all its acts, right? If the employer is having the sufficient evidence to prove that he hasn't asked his employee to perform so. Okay, so duty to exercise reasonable care and skill, right? That is one of the duties. And duty of confidence. You must always, if you are the employee, you must always protect the confidence of that is actually again working for the best interest of the the employer, and also protecting the conflict of interest. It also happens here, right? So duty of confidence, you protect some of the confidential information with you, not revealing to the others, right? And duty of fidelity, right? Fidelity is like an employee to have regard to their employer's interest. That is actually again not the best interest of the employer, but you have to act to the interest. Now you must always care about the interest of the employer, right? Okay. Now what do you mean by employment law? Simply, employment law is the law which considers about the employment, right? That is a simple answer that you can give, right? But here we say employment law should be a set of laws. Here there are two types of laws, right? Statutory constitutional laws and the bylaws. Bylaws are the laws which are imposed by the local government parties, local government organizations like municipal council and so on and so forth, right? So rules, the laws and the bylaws, right? The laws that deals with the rights of employees and the responsibility of the employers are known as the employment law. Now it's obvious, whenever it comes to the employment law, it's clear that employment law exists, that is to make the justice to the employees, right? Okay, so common law on employment consists of three elements, right? Now common law says, now employment law deals with three things. What are those? An intention from two parties to bound by a contract. Now if the intention has not exist, right, so the agreement between the parties cannot make as the legal contracts, right? In common law that says to make an employment law applicable to an institution or a sort of a relationship, the intention of the two parties is a must to bound by the contract, right? An agreement by both the parties as to terms of their employments, right? Whatever the agreements and the terms and conditions of agreement, or let's say based on the employment only, the parties have agreed, right? And third one is consideration and promises made by both the parties. Consideration is basically, when it comes to the employment contracts, consideration is a salary and other remuneration which are paid, and that will be counted as a consideration of contract of employment. And the promises which are made by the especially by the employee, which are agreed by the employee, are known as the promises, right? Then what is a contract of employment? If you look at, these are not offer of employment, right? I should say, I told you about when I was working on and when I was talking on this offer and acceptance principle, I told you that it's like a paper advertisement. Let's say if somebody has advertised something is not an offer, right? That is invitation for an offer, invitation to an offer, right? Invitation to an offer is not a valid offer. That is what I've told, right? So in this case, suppose if you are trying to apply for a job, you may refer an internet website, or else you may refer some magazine. If you refer a newspaper, so there you can see some of the advertisements are posted in whatever the materials that I've said, right? So in case where you have referred a material and you have depicted some of the advertisements, and if you are applying through, so that is where you make the first offer to your employer, right? Where they have made an offer, I mean there was an invitation to offer, right? They invited you to make an offer, right? So invitation to offer is your newspaper advertisement. So if you made any post, let's say by sending your curriculum vitae, right, by sending your application, you make a sort of an offer in order to recruitment, right? Selection, recruitment and things like that. Now in the case of contract of employment, once you have selected, let's say if you suppose that you have selected for a position, the company would give you a document known as an offer letter, right? That is not the contract of employment, that is your offer, right? Where the company will tell, under the case of designation, let's say under the particular position, you will be paid with this much of sum per month, and all the and will be recruited under the whatever the basis, let's say the permanent or contractual, or let's say that is basically subject to a probation anyway, and whether it's an apprenticeship, likewise they will tell the nature of the job as well, and will ask for your acceptance on their offer, right? You know that if you are going to make a sort of a counter offer, the offer will be void, right? That becomes voidable contract, right? So you are not going to sign a contract again, right? If they are asking you for a sort of 35,000 salary per month, if you are asking for no 50,000 salary and revise them and to come back to you, then it will be a counter offer on their particular offer. So that case, the contract may become voidable, right? You cannot sign any contract if they have not agreed with that, right? That is how negotiate with contract terms, right? But remember, when the offer is received to you, if you have accepted by signing and sending it, that is your acceptance, right? That is your acceptance on offer. But still the contract of employment doesn't exist. Contract of employment is an employment contract, or contract of employment is a kind of a contract used in labor law to attribute rights and responsibilities between the parties to a bargain. The contract is between the employee and the employer, right? So the contract of employment or letter of appointment and the contract of employment is coming at the next stage where you have agreed with the offer, right? So contract of employment deals, basically this is not letter of offer, this is not letter of appointment, right? Contract of employment in the sense this is the legal agreement between the parties known as the employer and employee, right? So that defines the responsibilities and rights, whatever entitled and whatever due by the employee and employer, right? So we'll move further. Now here, see, I've given you a sort of a pictorial descriptive, this is sort of a flow chart where contract of employment, for the contract of employment and how it's made. Now when it comes to the employee offers, you can see employer offers with terms and conditions to the employment, right? That is where the employer makes the offer, right? The this has to be employee, right? I'm really sorry, this has to be employee accepts the terms and the conditions on the employment, so where your agreement has already been made, right? See, the consideration is basically the payment or the salary. So considering all these three conditions, offer, acceptance and consideration, the agreement exists, right? Contract of employment is known as, basically it creates an estoppel where the party who agrees to perform the things, let's say the employee cannot refrain from performing whatever the activities that he agrees to do so, and the employer is liable to pay whatever the allowance or whatever the remuneration that he agrees to pay, right? So where you have a sort of a estoppel there, right? And the performance or the consistent or the existence of the contract happens when the two parties are performing the contract, that is by the salary and the performance, right? Then common types of employments. When it comes to Sri Lankan context, or even when it comes to foreign context, you can see different types of employments, right? You may have heard of these terms, right? Be careful and be mindful whenever it comes to your case as well. So be mindful. The reason is you are having different types of employments, right? Permanent employment, contractual employment, employment subject to a probation, basically it happens, casual employment and apprenticeship, right? Apprenticeship. First one is a permanent employment. Permanent means that it can be just after your probation, after a confirmation, it can be after reason, 2-3 types of contracts, contractual employments, right? You will be given with a full-time employment, right? This is not related to the full-time or the part-time, right? But permanent employment, full-time employment, which is after in a confirmed nature, and the employment will be running or employment will be conduct until the retirement and or until the insolvency of your company, right? No one is going to, the permanent employees, unless otherwise you have terminated under serious grounds, right? If the employer asks you to leave, you can continue your work without any hassle until the expiration of this, until the expiration expiration happens is until the cessation of this employment, means that until the minimum age of retirement, at the completion of the minimum age of retirement, right? And contractual employment, of course, it's like, recruited work for, for work under full time or maybe part time basis, but for a specific period. Now in contractual employment, there are two dates known as the contract, the beginning date of the contract or the start date of the contract, and the date which contract ends, right? So that contract end date will be considered as the date of cessation of contract. In some cases we see, right, most of the cases where you have massive sort of a card, let's say 15,000 16,000 employees, right, or let's say more than 5,000, let's say, in some cases, right, they include a factor called ipso facto cease, where unless otherwise you are informed, you will be ceased your employment at the date of the cessation of this contract, right, where you are no longer be able to work with that particular employer. And also at the case of ipso facto cease, or let's say if they have included a term called unless otherwise specified you in advance, right, you cannot claim any damages, or you cannot claim any wages after the date of cessation of your contract, right, because employer is not abide by the law to provide you with the the employment, or else to give you the work, right? And also you are not responsible and you are not reasonable to work with them after the cessation, even if they have not given you with a renewal of contract, or let's say for the continuation, right? Hope you would understood. Then employment subject to probation, where the probation exists, right? As an example, when the employers have made the recruitments as the employees, right? So once the employees are recruited, employees are given with a probationary period, where known as a sort of, it can be a training period in on the job, as well as it can be then evaluation period, right? Just after the probation, or until at the cessation of the probation, there will be a, even before the probation ceases, it starts, right? There will be a sort of an evaluation by the immediate supervisor, and based on the comment of the immediate supervisor, the HR will decide whether to continue the employment or not, right? So in the case of probation period, right, the period subject to the employment, now just after the completion of the probation or successful completion of the probation, just after the confirmation, it can be recruited as a permanent employment or a contractual employment. It's up to the employer to decide, right? And it's up to the recruitment policy, right? No one is going to care. But anyway, in Sri Lanka there's a rule where you cannot have, you cannot renew contracts for more than three times, right? If you are going to give them the offer of contract of employment, let's say the contractual employment, so you cannot offer or you cannot renew the same contract for three times, right? There are so many various types of laws, right? We will see what are these things in our descriptive, or let's say examination focus sessions, right? Okay, the third one is a casual employment. It's basically it's given to the employees, in the sense the people or labor, basically only for a guaranteed work period. Let's say daily wages. As an example, if the garment factory doesn't have sufficient cadre to perform whatever the line work, so based on that, they will ask the people, those who are from, like, basically the garments are located in villages, so they will ask some of the people from that particular village to come and join with them for that particular day, right, until the end of the shipment, right? They are not provided with a let's say statutory wages, right? They'll be given with a sort of an allowance, so let's call them as a daily wage, right? So they won't, the employer is not able to pay, and it's not actually wanted to pay whatever the statutory allowances and EPF and ETF, things like that in Sri Lanka as well, right? Okay. Then apprenticeship. Apprenticeship are the basic ways of systems of training the people, and it allows the trainees to work on the job, right? In some cases, basically the practitioners, like the industry practitioners, do apprenticeships, right? Those are, someone can, in some countries there are some laws where, they have to pay, the employers have to pay a minimum of incentive, right? But not statutory allowances, not like basic salaries and things like that, but just statutory allowances, right? Okay, fine. Now, some of the elements which are known at the contract of employment, or let's say this has to be letter of employment, sorry. This has to be letter of employment, where some of the elements of the letter of employment are known as a title and the designation, right, of that particular employment, and salary, remuneration, other benefits, statutory payments such as EPF, ETF, and contributions, right. The percentile contributions has to be mentioned, it's a rule. And also location of work. Now let us say if you are a factory manager, or let's say if you are a factory worker, you must mention with the factory name and the factory location, right? Otherwise they could, they have the capacity to employ you in anywhere else where their operations are located, right? So location of work is must, right? And in some cases I have seen some of the contracts are telling that you are abide by the rules and regulations of the company, and you are asked to work, you are required to work whenever you asked by the management, at the discretion of the management, whenever the management asks you to work at whatever the premises is owned by, or whatever the premises is operationalized by the same company or same employer. So if that particular term is included in your letter of appointment, so then the chapter is, or the whole this thing is finished. Why? You have to work for whatever the places that they say, right? So be careful before you sign all these contracts with the employers, because those are very tricky areas, because those people in general, they are not known to the law of the country, so they sign for whatever the employers will give. I'm not telling that employers are very sort of mysterious and those are like lying, but of course again I'm telling you, be careful and be mindful whenever you sign the contracts, right? And hours of work, as well as hours of work and entitlement for leaves and off. So whatever the entitlements and the hours of work, the number of works, or whatever the paid leave, paid vacation, everything is included. And the basis of employment, or the type of employment, whether you are probationary, under the probationary, or whether you are a permanent employee or contractual or whatever, that is mentioned under your letter of appointment, as well as the retirement, the minimum retirement age, the date of cessation of the contract, or the expiration, or else what are the types of dismissal and things like that will be included in your letter of appointment, right? Now, in the case of closure of employment, of course you can see there are three ways of closures, right? Closure in the sense that is the end of your employment, where it's happening through expiration of contract of employment, right? It happens through expiration, where expiration can happen in two ways, where cessation at expiry of contract, right? That is expiry, automatical expiration of the contract, where the contract date is due, right? The termination, or let's say the cessation date is due. And in some cases where you complete your age of retirement, right? So those are known as expiration of contract of employment. Then the next one is resignation by the employee, right? Resignation by the employee. Now when it comes to resignation, there are some notified or express resignations, as well as vacation of posts. Resignations can happen in two ways, where known as the expressed, let's say resignation after submission of a letter or proper notification, or else resignations after the let's call it as resignation of vacation. There is no resignation, again it's a way of vacation of post, right? Totally ignoring the duties and things, and vanish off from the location. Termination by the employer. In any case of let's say any dispute, any wrongful conduct by the employee, the employer will make necessary actions to stoppage and terminate the employment from the employer, right? Okay, so these are the things that I was expecting to touch today. So thank you very much, and hope you understood the lesson. Thank you.